Joining in today. This is a presentation for members of the BC Institute of Agrologists on Governance and Professional Conduct. My name is Angela Westmacott and I'm General Legal Counsel for the Institute. The presentation will cover off 7 areas. I'm going to start by talking about the concept of professional regulation that applies across the board to all professions in British Columbia and elsewhere. I then will talk about the complaints investigation process, the discipline process, the concept of what is professional misconduct, and the concept of unprofessional or off-duty conduct, and then talk about penalties for professional misconduct or unprofessional conduct, and the basic duties that all professionals have to their clients and to their regulatory bodies. So a profession at law is generally referred to as a relationship where a client places personal confidence and trust in the technical and expert competence of the practitioner, and the public as a whole places confidence in the integrity and ethical conduct of the profession as a whole. The basis of self-regulation is the recognition that members of a profession are best situated and equipped because of their specialized knowledge and expertise to establish and to maintain standards of competence and conduct for themselves and their peers. A profession becomes a self-regulating profession when the legislature, in this case the provincial legislature of British Columbia, passes a law that creates a regulatory body made up of members of the profession and some members who are publicly appointed by the government, and confers on that body the power to regulate the profession. The quid pro quo for the right of self-regulation is the responsibility to use that power to protect the public. In British Columbia, for agrologists, the law that governs the power to self-regulate is the Agrologists Act, and the regulatory body charged with that responsibility is the BC Institute of Agrologists. As I said, the power to self-regulate is considered to be a privilege. Statutes creating self-governing professions and the courts have confirmed that this power must be exercised in the public interest, not to advance the members of the profession. It's solely to ensure the protection and well-being of the public. That's codified in the Agrologists Act in Section 3.2a, which states that the purpose of the Institute of Agrologists is in part to uphold and protect the public interest by preserving and protecting the scientific methods and principles that are the foundation of the agricultural and natural sciences, and upholding the principles of stewardship that are the foundation of agrology, and ensuring the integrity, objectivity, and expertise of its members. That section also goes on to provide that the Institute has the duty to superintend and regulate the conduct of its members and to cooperate with other governing bodies or organizations on matters that are relevant to agrology. There are 2 core functions that a self-governing profession exercises, regardless of the nature of the profession. The 2 core functions are oversight over licensure, who gets to practice and become a member of the profession, and oversight over the conduct of professionals once they're admitted into the profession through the investigation and discipline process. In terms of oversight over licensure, the BC Institute of Agrologists exercises the power to control entry into the profession in 2 ways. First, it establishes criteria that are required to obtain membership in the Institute. So there are educational requirements, competency standards, requirements to demonstrate good character, of course fees and admissions. These are all detailed in the Institute's bylaws. The second method under the Agrologists Act are provisions that enjoin unauthorized individuals from practicing the profession of agrology unless they are members in good standing of the Institute. So Section 17 prohibits the unauthorized practice of agrology as well as the unauthorized use of title of agrologist unless an individual is a member in good standing of the Institute. And if there are people who are out there practicing agrology who have no right to be doing so or no right to call themselves agrologists, it should be brought to the attention of the Institute that can then take action by going to court to seek an injunction to prevent them from continuing to practice. In terms of oversight over conduct and competence, the Institute regulates conduct and competence by establishing and maintaining rules and standards of conduct and competence and ethics. Section 18 of the Agrologists Act authorizes the Institute to create standards of ethical and professional competency, including a code of ethics. And your code of ethics is, of course, contained in Schedule C of your college bylaws. The standards of practice and the ethics are enforced through the Institute's complaints and discipline processes. In recent years, the concept of self-regulation has come under increasing scrutiny and criticism. There are many in the public and academics who believe that self-governing professions are ineffective, that they prefer the interests of their own members of the profession to the detriment of the public interest. For example, in the health professions particularly, self-regulating bodies have been heavily criticized for imposing onerous licensing requirements on foreign-trained professionals, which is perceived by many to be keeping the doors closed on outsiders. Other concerns about self-regulating professions include concerns that self-governing bodies often provide ineffective responses to complaints by clients and consumers and provide weak sanctions in response to legitimate complaints. Governments are responding to these concerns by introducing either independent oversight for many professions or abolishing self-regulation altogether in British Columbia. For example, in British Columbia, the complaints processes and registration decisions made by BC's 26 health professions, medicine, dentistry, nursing, occupational therapy, physical therapy, and so on, are now subject to oversight by an independent tribunal called the Health Professions Review Board. So if the college's inquiry committee takes no further action on a complaint, the complainant can then seek review by the Health Professions Review Board, which is composed of people who cannot be health professionals, and they determine whether a reasonable decision was made or not. So that's a significant erosion of the right to self-govern for all of the health professions, that we're now under the scrutiny of this independent body in relation to most inquiry committee decisions and registration committee decisions. In 2011, the teachers in this province lost the power to self-regulate altogether. And background on that decision can be found on the report completed by Don Avison on the former BC College of Teachers, which is available on the website. But essentially, the government was concerned that the members of the College of Teachers were not addressing to complaints about teachers' conduct appropriately and were taking more of a protection stance for teachers rather than focusing on protecting the public. Now they're regulated by the teacher regulation branch in government. As a consequence, because self-governing professions are under increased scrutiny now, both by the academics and by the public and by government, it's critical that the Institute of Agrologists ensures that the integrity of its complaints and investigation process and its registration processes as well, that they must always be based on proper considerations. The professional regulation statutes all require self-governing bodies to establish a complaints and investigation process and also a discipline process. The Agrologists Act and the Institute's bylaws set out the details of what is required for a complaints investigation process and for discipline in this province. I want to turn first to the complaints investigation process. Before a self-regulating body has the power to investigate a complaint of the conduct of a member, there must either be one of two things. First, there must be a complaint from a member of the public or a member of the profession under Section 20 of the Institute's Act, or the Institute must reasonably believe that a member's conduct warrants investigation on its own initiative. So either a complaint can be filed, or the Institute can initiate an investigation on its own motion without a complaint, but only if there are reasonable grounds to believe that a member's conduct warrants investigation. The processes for complaints investigation and discipline are set out in sections 116 to 140 of the Institute bylaws. Section 20 of the Act states that a complaint may be made if the person believes that a member of the Institute has practiced agrology in an incompetent manner or has been guilty of professional misconduct, conduct unbecoming an agrologist, or a breach of this Act or the bylaws. And the concepts of professional conduct and conduct unbecoming an agrologist are terms that I'll be coming back to shortly in this presentation. So after a complaint can be filed, or the Council of the Institute can initiate an investigation on its own motion. And Section 21(1) of the Agrologists Act is the authority for initiating such an investigation. It provides that the Council may authorize an investigation into the conduct or competence of a member of the Institute if there is reason to believe that the member may have been guilty of one or more of the following: professional misconduct, conduct unbecoming an agrologist, or incompetent performance of duties undertaken while engaged in agrology. Where there is a complaint that leads to an investigation or an investigation initiated by the Council, that triggers a duty on the part of the member to cooperate with that investigation, to answer questions, and to provide any information and records that the Institute requires. A written complaint fulfills two important functions in the self-governing context. First, it informs the inquiry or investigating committee, in this case the Conduct and Discipline Committee, what it must investigate. Secondly, it informs the member of what is being alleged. It provides notice to the member of the specific conduct that is at issue that will be the subject of the investigation. Courts have described complaints as an expression of concern about the services or care or any other aspect of the professional relationship between a customer, client, and a professional. Section 116 of the bylaws requires that the complaint be made in writing. So as a consequence, the Council would not have authority to proceed with an investigation unless on the basis of an oral complaint, unless it was followed through in a written complaint. In the self-governing context, one looks first to the Act and the bylaws to see the requirements, but also superimposed on the requirements set out in the Act and the bylaws are the common law duties that are established by the courts through cases. And there is a huge body of law on the legal common law duty of fairness. The common law duty of fairness created by the courts requires that members know what it is that's being alleged against them in sufficient detail that they can have provide a meaningful response to the complaint. If a complaint comes in, a written complaint that does not contain sufficient detail, the complainant must be asked to provide for more information before the investigation can proceed. In legal parlance, it's called seeking further particulars of the allegation. So if a complaint comes in simply alleging that an agrologist was incompetent, that wouldn't provide enough basis for an investigation. The complainant would have to be asked to explain what actions of the agrologist are in issue, on what basis the complainant is alleging that the agrologist demonstrated incompetence, and to provide some further backup information. Even in situations where the Council of the College is initiating an investigation on its own motion under Section 21, it is still critically important for the Council to inform the member in writing of what specific concerns have prompted the investigation. Whether it's a complaint or an investigation on its own motion, the member must always have sufficient notice of what it is that is being alleged against them. Filing a complaint triggers a requirement under Section 20, Sub 4 of the Agrologists Act to follow up, either by conducting a practice review of the member's practice or by commencing a formal investigation. The duty of fairness established by the courts provides that an investigation must be fair to both parties, to both the complainant and to the member, although it's normally the member who has more at stake. Nevertheless, the Institute has a duty to be fair to both parties to a complaint. This always requires that a member will have the opportunity to review the complaint and respond to it. and that the complainant will generally have an opportunity to review the response from the member and to reply to it. So if you are the subject of the complaint, be aware that the process is transparent. Be aware that your response to the complaint will be shared with the complainant. And any further information that the complainant provides to the Institute will be shared with you as well. Sections 20 and 21 of the Agrologists Act and Sections 114 to 124 of the Institute bylaws and the legal principles of procedural fairness govern the complaint investigation process. But now I just want to highlight some of the key features of that process. First, the registrar, Bob Mooney, will receive complaints, and he ensures that the member has an opportunity to respond to the complaint. The registrar may also appoint a mediator, but only if the parties agree. So the bylaws contemplate that the registrar may offer mediation for a complaint, but it is an entirely voluntary process. If one or both of the parties to the complaint do not wish to pursue mediation, then it cannot go any further. The Conduct and Discipline Committee will authorize an investigation. The Conduct and Discipline Committee may authorize a practice review under Section 19 of the Agrologists Act instead of conducting an investigation, and after receiving the practice reviewer's report, it may still decide to commence an investigation and appoint an inspector to gather additional information. During the course of an investigation by the Conduct and Discipline Committee, as I said, the member is required to cooperate, to answer questions, to provide records and files and whatever evidence they have in their possession that's relevant to the matter, and to appear before the committee to discuss their conduct or competence. And that obligation flows from Section 21(1)(b) of the Agrologists Act. The investigator must only investigate the allegations that are contained within the four corners of the complaint. A complaint is not a vehicle for embarking upon a free-ranging examination of everything that the member does or everything about the member's practice. The scope of the investigation is limited to the complaint allegations. That said, if during the investigation other information comes to light that raises concerns about the member's conduct or competence in a specific way, the investigator would take that information back to the registrar and the Conduct and Discipline Committee, which may decide to initiate a separate investigation into that matter on its own motion. Generally, investigators are appointed to conduct site visits, to interview parties, and it may be and other witnesses and to gather additional records. So it may be that the nature of the complaint requires the Conduct and Discipline Committee to have other individuals interviewed, such as employees or other clients or third parties that may have relevant information to provide relative to the complaint allegations. At law, an investigation must be adequate, but it need not be perfect. There are a number of cases where parties to complaints in other self-governing professional contexts have challenged investigations, saying that they weren't sufficiently complete. The courts have held that an investigation must obtain sufficient information to allow the investigating committee, in this case the Conduct and Discipline Committee, to reasonably assess the actions and conduct of the member based on the allegations contained in the complaint. Courts have held it is not necessary for an investigating inquiry, such as the Conduct and Discipline Committee, to pursue exhaustively every avenue of inquiry. They need only obtain the type of information that would reasonably affect the assessment of the complaint. In terms of looking at the reasonableness of an investigation, courts are governed by the following factors. They'll look at the nature of the complaint, the seriousness of the harm alleged, the complexity of the issues, the availability of evidence, and the resources that are available to the regulatory body. Suffice it to say that where the complaint involves very serious conduct, such as gross incompetence resulting in the death of a party, The courts will expect an investigation to be extremely thorough and extremely diligent. But if the nature of a complaint is more in the nature of a quarrel between a client and a professional about the amount of fees that were paid, that's something that isn't going to necessitate the same level of scrutiny. The investigator must prepare an investigation report after interviewing the parties, interviewing any other witnesses, and gathering all relevant evidence. The investigator is not a fact finder. The investigator performs the role of gathering information for the Conduct and Discipline Committee, which must make an appropriate decision on how to dispose of the complaint. The report that the investigator prepares is shared with the complainant and the member, who are both then provided an opportunity to review the investigator's report and to provide any further written response to it that they wish. They may write in and say that the investigator got part of it wrong, here's what's really happened. They may say, well, the investigator did a proper summary, but there's some additional information you should be aware of. So there is a fulsome opportunity for the parties to respond to the investigator's report and ensure that they are fully heard before the matter goes to the Conduct and Discipline Committee. After the investigator's report is shared with the complainant and member, and they have the opportunity to provide written responses to that report, everything goes to the Conduct and Discipline Committee. The investigation report and the response is filed by the member and the complainant. And the Conduct and Discipline Committee must then decide what to do with the complaint. Sections 21(1)(c) of the Act and Section 122 of the bylaws provide that the Conduct and Discipline Committee can dispose of the complaint in the following ways. First, it may determine to take no further action. If the investigation reveals that the complaint is unwarranted, then and the conduct and competence of the member is fine, then that will be the end of the complaint process. Secondly, the Conduct and Discipline Committee may issue a written notice requiring the member to appear before it to discuss the conduct or his or her competence. Thirdly, the Conduct and Discipline Committee can authorize a practice review, which will then generate a report, and then they can look at what the appropriate result should be. And next, they can seek a consent order or take other remedial action. There haven't been many consent orders in the context of the Institute's work, but a consent order is a tool that's often used by other self-governing bodies where a complaint is substantiated. There are some concerns with the professional's conduct. The professional acknowledges that there was a problem, but indicates that he or she has changed his ways, and that agreement that the conduct won't be repeated is embodied in a formal written document called an undertaking or consent order, in which the professional undertakes not to engage in the conduct again and is perhaps required to take certain remedial steps as well. Finally, the Conduct and Discipline Committee can direct the issuance of a citation, which triggers a discipline hearing under Section 24 of the Act. Before turning to the discipline hearing process, I should add that there's been a recent amendment to the Institute bylaws that gives the registrar a summary dismissal power to dismiss complaints prior to referring them to investigation. If complaints are outside the jurisdiction of the Institute, if they are trivial, frivolous, vexatious, or made in bad faith, or they relate to conduct that does not raise a serious matter. The circumstances under which the registrar can exercise that discretion are fairly limited. It would have to be a very clear case to dismiss it without investigation, but nevertheless, that power does exist. I've completed my presentation on the inquiry and investigation process. I now want to talk about the discipline hearing process. You'll recall that I talked about the 4 functions of self-governing professions over licensure, and then over investigation of complaints, and then discipline. Discipline is the most serious process that a professional can face. If the Conduct and Discipline Committee issues a citation is drafted that sets out all of the allegations that are alleged against the professional that will be the subject of a discipline hearing. Section 127 of the bylaws sets out what this citation must contain. It must identify the member's name, the description of the matter that is the subject of the hearing, the date, place, and time of hearing, and the fact that a hearing may proceed if the member does not appear. A description of the matter that is the subject of the hearing sets out the particulars of the allegation. What precise conduct is being alleged against the member? The last provision that the hearing may proceed if the member does not appear reflects that the college has to serve the citation on the member. Once they can prove service of that citation on the member may choose not to appear in the hearing, but as long as the college or institute can show service, the discipline hearing can proceed in their absence. The institute has to provide full disclosure prior to the hearing. It must provide the member who's the subject of the citation with all of the relevant evidence that the institute has, whether or not that evidence is favorable to the member, at least 14 days prior to the commencement of the discipline hearing. Bylaws provide for 14 days, but generally more notice than that would be provided. The Conduct and Discipline Committee, which investigates complaints or conducts investigations on their own motion, does not participate in the discipline hearing process. That is the responsibility of a separate committee called the Discipline Hearing Committee. So members of the Conduct and Discipline Committee who are responsible for investigating complaints cannot be members of the Discipline Hearing Committee. Discipline Hearing Committee members would have no background in a complaint that's being investigated beyond seeing what's set out in the citation. A discipline hearing is a formal hearing process. It's normally conducted by a panel of members of the Discipline Hearing Committee, usually 3. Usually an odd number in case not all the members agree on what should happen. The discipline hearing is a formal process, much like a trial in civil courts. So for those of you who act routinely as expert witnesses in civil litigation, you'll have some familiarity with that process. The institute in a discipline hearing would have the burden of proof. They must call witnesses to give evidence to prove the alleged conduct. Those witnesses are then subject to cross-examination by the member who's the subject of the citation or by the member's lawyer. And the member is then free to give evidence and call witnesses to give evidence, and the member and his or her witnesses are also subject to cross-examination by the institute's lawyer. The laws of evidence apply, although not as strictly as they do in a judicial proceeding. So normally in administrative tribunals, the laws of evidence do not apply. They have some application in a discipline process because the stakes are so high for professionals, but they are not applied as rigidly as they are in a civil court proceeding. Discipline hearings are open to the public, although the Discipline Hearing Committee does have some limited discretion to conduct in-camera hearing, either in whole or in part, but it must be an appropriate basis to do so. Courts expect these processes to be transparent in much the same way that court processes are completely open to the public. At the discipline hearing, the institute is a party to the hearing, not the Conduct and Discipline Committee, but rather the institute. And the institute prosecutes the citation. They must prove the allegations against the member on a civil standard of proof, namely on balance of probabilities. That is 51%. They must prove that it is more likely than not that the allegations are true. During the hearing, members are afforded all of the procedural safeguards that they would have in judicial proceedings. They have the right to legal representation at their cost. They have the right to cross-examine all of the institute's witnesses. They have the right to present evidence and to make submissions on the evidence and the law, probabilities. It must then reconvene and conduct a penalty hearing. So discipline hearings are always bifurcated. The first hearing always deals with liability. Did the member engage in misconduct or incompetence? If so, then the hearing reconvenes to proceed with the penalty hearing. Sections 24(4) to 7 of the Act set up a range of penalties that a discipline hearing committee may impose. They include a formal reprimand, which is a statement that admonishing the member for engaging in misconduct, a fine which cannot exceed $10,000, conditions on registration. So, for example, the discipline hearing committee may say that the member must practice under the supervision of another registrant for a period of time, or must provide regular reports to the Conduct and Discipline Committee, or perhaps it would involve cooperating with random spot audits of their records. The Discipline Hearing Committee may also suspend the member's practice for more serious conduct, and suspensions can range anywhere from weeks to months to years, depending on the severity of the conduct in question. They may also, in the most serious cases, rescind membership and identify how long it is before a member can reapply for membership with the Institute. And the Discipline Hearing Committee also has authority to require other remedial actions, for example, requiring a member to take some ethical courses or educational courses, or to undertake other activities. When deciding on an appropriate penalty, courts have held that discipline panels must consider the following factors: specific deterrence of the member, general deterrence of other members of the profession, rehabilitation of the member, punishment of the member, denunciation of the conduct, the need to maintain public confidence in the integrity of the profession and the ability of the profession to regulate the member, and ensuring that the penalty is not disparate with penalties imposed in other cases. So these are the principles that apply to penalty hearings for all professionals. The goal is to ensure that the member does not engage in the conduct again, that other members of the profession learn from this conduct and that refrain from that conduct as well, to rehabilitate the member if that's possible, to bring them back into line with the standards of the profession, punishment for morally culpable behavior, also denunciation of the conduct if it involves morally culpable behavior, and ensuring that the public have confidence that the members be properly punished, and finally ensuring that the penalty is in line with other decisions of other discipline panels from other professions for similar conduct. So it's all about proportionality of response to ensure that the members are treated fairly, but also that the serious conduct is dealt with as such and that an appropriate penalty flows from that. I want to move from the discipline hearing process now to talk about the concept of professional misconduct. As I said, it's a defined term in the Agrologists Act, and it's usually defined in most self-governing statutes. Professional conduct means unacceptable conduct within the scope of a professional's practice. It's not what they're doing off-duty. It's not something that's unrelated to agrology. It's conduct that fails to meet proper standards that occurs while the professional is engaged in the practice of agrology. The Act defines professional misconduct as misconduct of a member of the Institute relating to the performance of duties undertaken while engaged in agrology and includes a breach of the bylaws. The standard for assessing what constitutes professional misconduct is whether the member's conduct in the pursuit of his or her profession would be reasonably regarded as improper by other competent and reputable members of that profession. So it really incorporates the standard of peer review by reasonably ethical and competent members of the profession. You're not held to a standard of perfection, it's reasonable competence and conduct. Professional misconduct also includes reckless and willfully blind as well as intentional conduct, but it does not include involuntary conduct. If it's conduct that arises from a medical condition that the member had no control over, that would be dealt with as a fitness to practice issue that would not give rise to a charge of professional misconduct. Examples of professional misconduct drawn from other cases, other professions include incompetent practice unrelated to medical issues, ethical breaches, excessive or fraudulent overbilling, failing to observe professional boundaries of clients or patients, any type of sexual misconduct with clients or patients, misleading marketing, unprofessional behavior towards a client or a patient, and any type of misrepresentation, whether in writing or oral. That's not an exhaustive list. The list seems never ending of what can constitute professional misconduct, but those are the types of allegations that surface most frequently when one reviews the cases. There's very little law on professional misconduct by agrologists, but cases from other professions provide good illustrations. For example, in one case, an architect committed professional misconduct when he misrepresented to a building inspector that a project was in compliance with the building code. Any type of professional misrepresentation will constitute professional misconduct. It's critical that you are accurate and honest in all of the representations that you make for any professional. Secondly, another architect case, an architect committed professional conduct when he put his own professional seal on a design plan that he had not entirely supervised. An engineer committed professional misconduct when he wrote a letter attacking the principal of another engineering firm. So there's an expectation of appropriate conduct in all of your communications, written and oral communications, and unwarranted attacks of any type will constitute professional misconduct. Another case involved a geoscientist who was found to have engaged in professional misconduct for not responding to his client's correspondence in a timely way, and that's all part of the communication. The one thing I would say, based on my years of working in the area of professional self-governing regulations, is that it's all about communication. Really focus on communication, and you will really mitigate your risk of having a complaint made against you. In another case, 2 accountants committed professional misconduct because they did not ensure that a company's financial statements were prepared in accordance with generally accepted accounting principles. An optometrist, this was the case I was involved in, committed a professional misconduct when he falsified clinical records. A patient alleged that an optometrist in Vancouver didn't do a proper eye exam and failed to refer her to a specialist. She was suffering from advanced cataracts. She filed a complaint. He then sent in some clinical records saying, I did refer, and here they are. When the College Inquiry Committee followed up with the specialist confirmed that he never received the referral note. And an on-site investigation of the optometrist revealed several versions of the clinical records. So he clearly falsified clinical records to try and cover over the fact that he had failed to make a referral. A lawyer committed professional misconduct when he was willfully blind as to whether 5 real estate transactions in which he involved were fraudulent. You can't turn a blind eye to feel something is amiss. You have a duty to investigate properly. Being willfully blind will not be a defense to a charge of professional misconduct. I said earlier that if your conduct arises from a medical condition over which you have no control, that will be dealt with as a fitness issue. And in a case a few years ago involving a teacher, he was charged with professional misconduct because he had screamed at a student. But the court held that that was not professional misconduct because his conduct arose from bipolar disorder, and he didn't have the mental capacity to appreciate what he was doing at the time. So the court held it shouldn't have been dealt with as professional misconduct. It should have been dealt with as a fitness to practice issue. I want to turn from the concept of professional misconduct to the concept of unprofessional conduct. There are a number of formulations of this term. There's unprofessional conduct, conduct unbecoming, or off-duty conduct. Generally, these terms refer to conduct of members when they are not engaged in professional activity, although the Agrologist Act defines conduct unbecoming an agrologist as conduct that brings the Institute or its members into disrepute, undermines the scientific methods and principles that are the foundation of agricultural and natural sciences, or undermines the principles of stewardship that are the foundation of agrology. I will say that this definition still has a fairly direct nexus back to the practice of agrology, but there still is the door that can be opened for going after someone for off-duty conduct that isn't directly linked to agrology, but impacts the profession adversely, as I'll demonstrate in a few moments with some examples. The test for determining whether off-duty conduct warrants disciplinary action is whether the conduct can be said to be, quote, significantly more reprehensible, close quote, when engaged by someone of that particular profession than when it is done by other professionals. Conduct must relate in some way to the profession as a whole and to the person's suitability to be a member of that particular profession. This sets a fairly high bar, fairly high protection for what one does in one's personal life because of the value that is placed on the freedom of professionals to act as they choose when they're not working. Let me give you some examples. In the case of Ross in New Brunswick, the school teacher was found to have engaged in unprofessional conduct when he published anti-Semitic material in his personal time because of the special nature of the teacher as a role model for children. So his defense was, I wasn't publishing this material during school hours or in any school materials. I was doing it in my own off-time hours in non-school related publications. That wasn't professional misconduct because he wasn't teaching at the time, but the courts held it did constitute unprofessional conduct because teachers should be careful about what views they espouse given their special role dealing with the vulnerable members of our population of children. Another example, an architect who ignored municipal bylaws and ignored stop work orders when he was constructing his own home. The court said the same conduct would not have constituted conduct unbecoming for a dentist or nurse or indeed any other professional because it would not have any bearing on their professional practice. But for an architect to ignore municipal bylaws and stop work orders was conduct unbecoming or unprofessional conduct because it reflected badly on the profession of architecture. A veterinarian who neglected his own animals. Again, the court said that neglecting one's own pets wouldn't be unprofessional conduct for any other profession, but for a veterinarian, that was considered unprofessional conduct. Similarly, an engineer who mishandled trust funds in his capacity as a manager of a mining syndicate. The court said his lack of honesty undermined his professional capacity to issue reliable reports, and that same lack of honesty reflected poorly on the profession of engineering. To give you another example where the court found that it wasn't professional misconduct, a pharmacist who had been extremely rude to customers in the pharmacy was found not to have engaged in unprofessional conduct because his behavior related to the business of retailing drugs, not to his professional duty of dispensing drugs. Courts have said in some cases that quarrels between professionals and their employers or between professionals themselves generally do not constitute unprofessional conduct, but there's always limits on that. It depends on the nature of the conduct at issue and how egregious that conduct is. Let me turn from unprofessional conduct or conduct unbecoming to the penalties that can be imposed for professional misconduct or unprofessional conduct. As I said earlier, a discipline panel may impose a number of penalties under Section 24 of the Agrologists Act at the conclusion of a discipline hearing. We talked about a reprimand, a penalty that can't exceed $10,000, conditions on registration, suspension, rescinding registration as a member, and requiring a member to complete remedial programs. There's also an emerging area in professional self-regulation called ungovernability. An essential component of self-regulation is that members of the profession must be willing to be governed by the regulatory body. An ungovernable member describes a person who is either unwilling or unable to be governed by the regulatory body. A finding of ungovernability by a regulatory body will result in the member losing his or her privilege to practice the profession. The test for ungovernability is set out in the Law Society of Upper Canada and Schiffman. The court, and this is a test that's applied by other discipline panels of other professions as well. The panel will look at, is the nature, duration, and repetitive character of the member's present or past misconduct sufficiently serious that it suggests an unwillingness or inability to be governed by a regulator, in this case the Law Society, notwithstanding progressively increased penalties for repeated incidents of misconduct. So, looking at ungovernability is not something that will be raised the first time a person is going to a discipline hearing. But if they have a long discipline history, they've been through other received disciplinary sanctions and other complaints, and their conduct is escalating, and they're not changing their ways, then the issue of ungovernability comes onto this stage. So, going back to the test, in light of all the circumstances, is revocation of their membership appropriate? And this involves a balancing of the nature of the misconduct at issue and the disciplinary history of the member against any mitigating factors in the member's favor, including any character evidence. Has the member shown remorse, recognition, and understanding of the seriousness of their misconduct? Has the member provided evidence that they're willing to be governed by the regulator in future? Have they provided any medical or other evidence to justify the misconduct? What's the likelihood of future misconduct, having regard to those remedial efforts that have been undertaken? And the member's ongoing cooperation with the regulatory body in addressing any outstanding matters that are the subject of the misconduct. Just before going on to the duties of professionals, I will say that the College of Optometrists recently dealt with the case of ungovernability. That same optometrist who provided falsified records. You can go on the College of Optometrists website and look at the case of McKenzie, and that was an individual who was ultimately suspended from registration. He persisted in practicing without registration. The college went and got an injunction to stop him. And even after the injunction, he continued to practice and then went through contempt proceeding. And the college took him through another discipline hearing, which found that he was ungovernable and he now cannot practice optometry again. Turning to the final section of this presentation, I just want to talk about the duties of professionals. It applies, of course, to agrologists. These duties apply to all professions. All of us who are engaged in providing professional services to the public. All professionals have fiduciary obligations to their clients or patients, a duty of loyalty to act in the best interests of their client, not for their own self-interest. They have duties of confidentiality to keep the work done for the client confidential and to protect any personal information from disclosures required by privacy protection laws. For agrologists who work for public bodies, those obligations are set out in the Freedom of Information and Protection of Privacy Act. For those of you in private practice, you are considered organizations within the meaning of the Personal Information Protection Act, and you have obligations to maintain confidentiality and privacy under that act. Professionals owe a duty of care to exercise a professional standard of care in the performance of professional services. The duty of care applies not only when a regulator is looking at whether someone is competent and provided a reasonable level of service. In the case of someone who suffered damages or loss or injury of any type as a result of the lapse of the duty of care, they can bring a negligence claim in civil courts for damages. And that's another concept, duty of care, which will be applied in that context as well. A duty to warn. There's a duty to advise clients or patients of any known risks or deficiencies. In addition to those 4 core duties that professionals have, I want to hit on some additional ones in the hopes that it will be helpful to you in terms of carrying out your practices. Professionals have the duty to practice in accordance with the requirements set out in their governing statutes, regulations, and bylaws. You should be aware of the requirements set out in your institute bylaws, particularly including the codes of ethics. For lawyers, we have extensive requirements set out in the Professional Conduct Handbook, which goes on for quite a length that we have to be familiar with. Professionals have a duty to comply with professional conduct standards, including any standards of practice that are written. Professionals can also be held to unwritten standards of practice as well. But as long as you're practicing in a competent manner, you'll be in compliance with unwritten standards. Professionals have a duty to comply with the ethical obligations set out in their code of ethics, and you have a code of ethics in your Institute bylaws. To avoid conflicts of interest, the Institute also has conflict of interest guidelines, something to always be very careful of. This is well-tilled ground for professionals in the area of complaints. You have to be very diligent about avoiding conflicts of interest. Always ensure that they are and remain competent to practice, which includes maintaining currency through regular continuing education programs. Many colleges now have mandatory continuing education programs. For example, as a lawyer, I have to complete 14 hours of mandatory continuing education every year. Many self-governing professions are moving towards mandatory continuing education. But even if it's not mandatory, it's an important part of being a professional and to ensure that you are remaining current of any developments and changes in your field. To communicate clearly to others, and I can't emphasize this one enough. I say here that any ambiguity will be resolved against the professional. If there is a dispute about what a contract means and the contract has been drafted by the professional, the court, in the event of litigation, will interpret that contract in a manner that's most favorable to the client. So be very clear in how you communicate, both in your written and your oral communications, because 90% of complaints stem from lack of communication. Make sure that you understand the scope of your retainer to take on work, and ensure that the client understands the limits of the services that you can provide to them. Ensure that you stay within the scope of your expertise as a professional, including ensuring that you have the necessary experience and background to carry out the work that you've been retained to do. If part of that work or all of that work is outside your area of scope of expertise, refer it to another colleague who has the expertise to do the work, or collaborate with another expert who has that expertise. Critically important to maintain and complete accurate records. Courts consider timely and accurate record keeping to be essential to providing proper professional service, and poor record keeping is often considered to be a flag for other problems in a professional's practice. With some professionals, particularly those who have lengthy discipline history with colleges or institutes, when a complaint comes in, before they're even given notice of the complaint, some investigating committees will just send an inspector to go and grab the records to see what they look like, because if they're concerned that these records might be augmented or changed after a complaint comes in. I can't stress enough the best defense that you have, the best protection that you have against a complaint or civil suit is to maintain proper records that will document what occurred at the material time. Courts place a lot of reliance on contemporaneously made records because they're written at a time before you know that there's going to be an issue. So both courts and disciplinary panels place a lot of emphasis and a lot of reliance on records. Bill, reasonable and fair fees, that's probably an issue more for lawyers than anybody else, but be cognizant about, make sure that your fees are in the realm of reasonableness. Self-governing professions aren't in the business of regulating fees unless they're exorbitant or unless there's some element of fraud or exploitation. But by ensuring that your fees are in the reasonable range, you will significantly limit your exposure to potential complaints. Make sure you cooperate with any investigation. I've already flagged that duty as set out in the Agrologists Act. If you're retained to provide expert reports, ensure that your opinion is impartial, based on the facts that are provided and within your scope of expertise. Do not engage in advocacy when you're providing an expert report to the courts or to a tribunal or for any other purposes. Make sure you're properly qualified to provide that opinion and that your opinion is properly supported by facts, whether they're actual facts or hypothetical facts. Make sure that any opinion or report that you provide sets out the underlying facts, whether real or hypothetical, your chain of reasoning in reaching your conclusion, the limitations of the opinion, and any reference material that you're relying on. The Institute has not received many complaints about agrologists, but the few complaints it has received, many of them involve expert reports or expert opinions. So I hope these pointers are helpful the next time you sit down to prepare an expert report. You'll have far more credibility with the court if you're not engaged in advocacy and you're giving an impartial and well-documented and well-substantiated opinion. That concludes this presentation. This presentation can be uploaded. There is something on your screen where you can upload it if you want to look at it later. I hope it's helpful to you in your practice, and if you have any questions, please feel free to call the Institute or to call me directly. My contact information is on the final slide. Thank you.